5 seconds to go. Start. It was observed that normalization of marks means increasing and or decreasing the marks obtained by students in different timing sessions shifts to a certain number as observed by the High Court in its judgment, and it was noted that such normalization techniques help in comparing corresponding normalized values from two or more different data sets in a way that it eliminates the effects of the variation in the scale of the data sets. That is, a data set with large values can be easily compared with a data set of smaller values, and the normalized score percentile is obtained by applying a formula. This court accordingly concluded that the exercise undertaken in adopting the process of normalization was quite consistent with the requirements of law. This court further observed that decisions made by expert bodies, including the public service commissions, should not be lightly interfered with unless instances of arbitrary and mala fide exercise of power are made out. On similar lines, in Tejveer Singh Sodhi and others versus State of Jammu and Kashmir and others, this court observed that interference in the selection process for public employment should generally be avoided, recognizing the importance of maintaining the autonomy and integrity of the selection process, noting that courts would recognize that the process of selection involves a high degree of expertise and discretion, and that it would not be appropriate for courts to substitute their judgment for that of a selection committee. It was observed that it is not within the domain of the court exercising the power of judicial review to enter into the merits of a selection process, a task which is the prerogative of and is within the expert domain of a selection committee, subject, of course, to a caveat that if there are proven allegations of malfeasance or violations of statutory rules, only in such cases of inherent arbitrariness can the courts intervene. The detailed explanation by the experts being rather technical, we do not propose to burden this judgment with the same, but the learned senior counsel opposing the MPPSC, who also heard the experts, did not bring to our notice any lacuna in the process adopted or the formula applied whereby injustice was done to any candidate or any arbitrariness crept in. We therefore hold that the process of normalization and the consequential merger of the marks secured by the candidates who appeared in the two main examinations cannot be found fault with. We may also note that Rule 43D third of the Rules of 2015 patently harmed the interests of the reservation category candidates, as even meritorious candidates from such categories who did not avail any reservation benefit relaxation were to be treated as belonging to those reservation categories, and they were not to be segregated with meritorious unreserved category candidates at the preliminary examination result stage. As a result, they continued to occupy the reservation category slots, which would have otherwise gone to deserving reservation category candidates lower down in the merit list of that category had they been included with meritorious unreserved category candidates on the strength of their marks. In Saurav Yadav and others versus State of UP and others, a three-judge bench of this court affirmed the principle that candidates belonging to any of the vertical reservation categories would be entitled to be selected in the open category, and if such candidates belonging to reservation categories are entitled to be selected on the basis of their own merit, their selection cannot be counted against the quota reserved for the categories of vertical reservation that they belong to. It was further observed that reservations, both vertical and horizontal, are methods of ensuring representation in public services, and these are not to be seen as rigid slots where a candidate's merit, which otherwise entitles him to be shown in the open general category, is foreclosed. The bench further observed that the open category is open to all, and the only condition for a candidate to be shown in it is merit, regardless of whether reservation benefit of either type was available to him or her. Stop.